prepare in preparation for the issuance of a policy of title insurance. And most people get policies of title insurance. There's no law that mandates it, but by the same token, if you don't get a policy of title insurance, it means you've got money to burn. Because while we don't have a lot of claims, obviously the purpose of going through a title company and getting the transaction insured is to make sure you don't have claims afterwards. But if something does go awry, it is a policy of insurance, and we do cover the matters that are covered by the policy. So the preliminary title report, the packet I've got, it gives you an example preliminary report. And if you go to page 4 of your package, it gives you the face page of a preliminary report. Tells you who issued it, Doma Title. By the way, Doma has a long history. It's been around for a long time. It gives you the name of the people who requested the report and the name of the escrow officer, our file number. We give every report we issue a separate file number, the address of the property, and then the preliminary paragraph. Now, this paragraph was prepared in an agreement between the title insurance industry and the title commissioners, the insurance commissioner's office, so that it would tell people what they were getting. That it is a preliminary report. It's issued in anticipation of issuing a policy of title insurance. And it says the report can be supplemented and whatnot. And item 6 tells the type of policy we anticipate issuing. So it's important to look at that. If it's residential property and its primary use is residential, you want what we call an America First homeowners policy. It gives you coverage above and beyond what's in an ordinary policy of title insurance. Then on the next page, we tell you what interest the seller owns in the property. Fee means that that they have the right to sell or convey the property. It could be a fee. I just had a person call me a bit confused because they had a pre that said the estate was leasehold. Well, that's because that's what the seller owned. He owned a lease in a condominium unit down in Southern California. And so it tells you the type of interest you have, the seller has in the property. Fee means you own the dirt, the building, and all of the elements of it. Then it tells you who owns the property. It's a good idea to look at that. A lot of times people think that, well, title should be in John Smith and his trust. And when we search it, there are errors in documents that have been recorded and title didn't get there. So it's a good idea to look at it. I had a call from an escrow officer this morning. A woman is trying to sell property that her deceased husband had owned. She went through probate. She thought she owned the property, but based on the probate, she only owned a half interest in the property. So it's a good idea to look at the vesting and see who owns the property and how they own the property. Then the next thing is the legal description. If it's lot and block, lot 12, block 12 of track 1, 2, 3, it's a good idea to look at the map attached to the pre to make sure they match. Make sure a meets and bounds like this, it tells you the southerly 25 feet of lot 3 through 8. Well, if you look at your report and the map attached to it says you're 5 through 7, then you know you've got a problem. So it's a good idea to just glance at it and the map. Then on the next page, we start the items in Schedule B. Schedule B is where we show those matters that when we issue the policy of title insurance, we will take exception to. In other words, a claim or matter arising out of these items would not be covered. The first item is general and special taxes. And you notice it's for the year 2019, 2020. It's always a 2-year. And under California law, real property taxes cover a fiscal year. The fiscal year begins July 1st of one year and ends June 30th of the next. So property taxes are always 2013, 2014. And the current taxes that we're getting bills for now are for 2022 and 2023. So you'll always see 2 years. The interesting thing, though, is under California law, the assessor assesses the property based on who owns it January 1st of the year where the fiscal year begins. So if you were getting a tax bill now, it would be given to the owner who owned it on January 1st of 2022 based on its condition on January 1st of 2022. So if under, I don't know how many of you even remember Prop 13, you'd have to be a bit older than probably most of you are, but Prop 13 was passed by the voters of California in 1977. And what it said was that the assessor can only increase property taxes by a maximum of 2% a year, and that he can only go on amount greater than that if there is work of improvement that increase the value of their house, or if there has been a change in ownership. For instance, I live in a house in Union City, California. When I go on the various services that give you estimates on the value of the property, my property is it would market based on what I'm told for about $1.8 million. But the assessor only assesses it for around $700,000. Why is that? Well, I bought it in 1981 and for $106,000, so that became my base. Then I did some work of improvement, so it got increased for that. Then I added a second story, so it got increased for that. But even with all of those changes, my assessed value is still less than half the value of my property if I were to try and sell it. So it's a good thing. It's a good idea to look at the taxes and make sure that you're seeing everything. And if there's been a change of ownership between January 1st and the time we're issuing the report, then there would be a supplemental tax bill. And in this case, so the first item is the taxes not yet due or payable that for the 2019-2020 year. Now, for this year, that would be 2022-2023. The next item is the taxes for the prior year. Why do we include the taxes for the prior year? Tax bills aren't out yet. The escrow has to have numbers to prorate on. And also in this case, since these are for 2018-2019, and we're in the year 2019, the second installment of taxes still had to be paid. So it's to give escrow the information about taxes. Then the next item in the chain, in this case, is a tax default. That means the property owner didn't pay their taxes, so a tax default was issued. The assessor issues tax defaults after June 30th. So you have taxes from July 1st through June 30th of the next year. If the taxes aren't all paid by June 30th, then there's a tax default, and it carries a 10% penalty plus 1.5% a month penalty. So these numbers change monthly. Then you have the item 12 is supplemental taxes for any change of ownership or work of construction. So we have to check for those. They included a notice of power to sell. That's a notice where the county, it's been 5 years, the taxes haven't been paid. And so the assessor is now going to sell the property to pay the property taxes. And the 90% of the pre's you get aren't going to have item 13, the defaulted taxes, because most people pay their taxes. Usually you've got a loan and whatnot. Item 6, which you won't see in most pre's, except in rural properties, is rights to water and water not shown by the public record. So what we're not ensuring is your right to access water that might be underneath your property. You can't necessarily drill a well. And in most jurisdictions, you have to go to the local water agency to get permission to drill a well. So if you have a person who's buying agricultural land, then water rights become an issue, and you need to check and find out what those water rights are. Item 14 of the report is covetous conditions. In other words, if a developer is developing a subdivision, he will issue, he will record a declaration or covenant restricting the use of the land. It's important to look at those. A lot of times there's a homeowners association if there's common facilities that need to be maintained. So those are things to look at. In this case, we tell you in item 8, look for a homeowners association. So it's a good idea to inquire of the seller if he's got a homeowners association, and if so, who are they and how do they collect their dues? Item 16 are easements. Easements are the right of another person to use a portion of your land for a specific purpose. Public utilities, could be a driveway, could be a roadway. It's a good idea to look at the easements, see what they're for. And if you need to, you can ask. We usually can prepare a color-coded map that will show you the property and where the easements are on the property. It is a good idea to request one if you don't get one automatically, because of the fact that obviously if I'm buying a lot, I want to know where the easements are. I don't want to suddenly find out there's a gas line running underneath my house. So easements are important to the right of a third party to use a portion of your land. Item 17 is a deed of trust. The deed of trust, as you all know, is where you've borrowed money for the improvement or the purchase of the property. You have to repay it. We always show them. Usually we highlight them in yellow now on the pre to call your attention to the fact that there's a loan and it has to be paid. So that's a thing to look for. If property is free and clear, we always ask the seller to confirm that the property is in fact free and clear, that there are no loans on the property. I've had situations where a loan was made, but it had an incorrect legal description, or for some other reason appeared not to affect our property, and it in fact did. So we always ask the seller, are there any loans? And it's a good idea to be aware of that. If the loan is in foreclosure, we show a copy of a notice of default for the loan. If it's getting close to being sold, we'll show a notice of trustee sale. These are things that tell you you have restricted times and you may have problems. You want to deal with the lender, see if you can get them to delay the sale. By the way, this pre shows a lot of things that you wouldn't typically see in a pre, because they wanted to put in issues to call your attention to. Notice of postponed property taxes due. So that's an exception that tells you that the assessor postponed taxes, but they are outstanding, they are due. We got more deeds of trust. The next items are on the next page, and those are monetary liens that are liens against the individual, and because they're liens against the individual, they're liens against all the property he or she owns. The first one is an abstract of judgment. That would mean a money judgment entered into a court case. Usually we have to approach the attorney or the judgment creditor on that to get a demand, and we need a satisfaction of it. Lien for unsecured taxes. Unsecured taxes, let's say the seller owns a boat and the assessor assesses the boat, sends him a tax bill, and he doesn't pay it. He doesn't pay it, then the assessor records what's called a Unsecured, excuse me, unsecured tax lien. An unsecured tax lien is like an abstract of judgment, and it has to be paid, and it affects all the property the seller owns. In this case, we've got also a solid waste lien or a garbage lien. Most garbage agencies have contracts with the local jurisdiction to collect garbage, and as a result, if you don't pay your monthly garbage bill, then they can record a lien against the property. And so that's a lien that is often recorded. So you want to look and see what liens against the property. The next lien is a code compliance lien. Yeah, code compliance, if you haven't maintained the property, if you have garbage in the front yard, if you added a structure to or building to the house and you didn't get a permit, local jurisdiction will oftentimes record a code compliance lien. The thing that's tricky about these liens is they'll have an amount, $200 or $300. That's to pay the fee for filing the lien, but that doesn't correct the error. So with these liens, it's a double-edged lien. You have to not only pay the lien, but you also have to go to the planning department, find out what you need to do to clear the lien, and then you need to make those repairs to the property. So if you've got a code compliance lien, it's in this case you can see that it's well, they don't even show an amount, but a lot of times they'll show a small amount. And people think, oh, it's $20 or $30. Well, it's $20 or $30 for the code compliance people, but you still have to clear the lien. You have to go out and correct whatever it is, and that can sometimes be thousands of dollars. Item 20 is a lien. There are what is it? Y-Green and Hero liens are liens for their entities that can loan the person money to make improvements such as solar improvements or a new roof, whatever, to maintain their property. And the lien is recorded, and then it's actually collected with your taxes. So a lot of times you'll have a person who has an older home. Taxes look like they're a nominal amount, but there's one line item that is a few $1,000s. That's the energy lien. And when they sell the property, that lien has to be paid off in full. So if you see that kind of a lien, it means that you need to ask them if they've gotten energy under the Hero program or the Y-Green program to make improvements to the house. Could be windows, it could be a water treatment system, solar panels, one of those things. And if they have, then we have to order a demand from the entity to pay those things. Next item is a financing statement. Also, a lot of people who put on solar panels don't own the solar panels. For instance, I have solar panels on my roof, but I don't own them. They're owned by Solar City, and I pay a monthly fee for the electricity I get from those solar panels. So there's a contract between the property owner and the solar panel company for payment for the solar energy you get, that you can buy the contract out, but you don't own the solar panels that are on your roof. So so if a person has solar panels on their roof, you need to find out if they have a solar contract or if they actually purchase them outright. And that could also include battery packs that are, they sometimes call them Tesla walls. It's a battery, and as the solar panels generate electricity, whatever the homeowner doesn't use, it goes to the a battery pack, and then when the sun isn't out shining, the battery pack produces energy. So it literally takes you off the grid, but you don't own them. They're still owned by a third party, Solar City or somebody else. So if you see solar panels, it's a good idea to inquire from the seller. Did you buy the solar panels, or do you have a solar contract with a solar service provider? No, because then you know it going in. A lot of times lenders insist that the contracts either be paid off or subordinated to their loan. And it's interesting because the contract says that the solar panels do not affect real property, because the solar panels are just like the sofa sitting in the family room, except for the fact that the solar sitting in the family room belongs to the property owner, whereas the solar panels belong to somebody else. And let's see. Then claim for well, item 30 is a mechanics lien. That's a lien. Somebody did work on the property. They claim they didn't get paid, so they filed a lien, and it has to be cleared. Solar or mechanics liens are in effect for 90 days. They can be extended for an additional 90 days. For us, the issue is if there's one mechanics lien, are there more? In other words, if you hired somebody to remodel your kitchen and he didn't get paid, he has the right to file a mechanics lien. But beyond that, if you hire somebody to remodel your kitchen and they don't pay the sheetrock guy for the sheetrock, they don't pay the cabinet guy for the cabinets, they don't pay the plumber for the plumbing work that they're doing, the electrician for the electrical work, all these people can also file liens. So when we see one mechanics lien, we have to inquire what was done, who got paid, have they been, can you show proof of payment? So it's important. So it's important to consider these things. Mechanics lien gives the mechanics lien claimant the right to go to court, get a judgment, and sell the property to pay for their mechanics lien. So it is an issue, and you have to consider it. The next item shows a deed, and that would be if we had a questionable deed. Let's say you have mom and dad in title, and mom and dad deed the property to their children. We would want to go back to mom and dad and say, did you really do that? All too often we find out that the deed, they didn't understand what they were doing. They thought they were just letting the son live there, and all of a sudden, he owns the property. So anytime we have what's called an uninsured deed, a deed that didn't pass through and get insured by a title company, if it's relatively recent, we will want to go back to the grantor and ask them, did you sign that deed? Did you get everything you're entitled to for that deed? So that is what that item represents. Item 32 goes back to the idea of money judgments and tax liens. When those are recorded, they don't describe a particular piece of real property, they just have a name. So if the seller in my transaction is John Smith, then, and I run John Smith in the recorder's grantor grantee indices, it means that I'm going to have a lot of items. John Smith is a very common name, and names that years ago we didn't consider common have become more common. And so we have to ask the property owner, the seller, for a statement of identity, giving us information about them: social security number, date of birth, where they've lived over the past 10 years, where they've worked, so that we can use that information to clear liens that might be against them. I remember years ago discovering the fact that my name's William O'Connell. There was another fellow, I live in Alameda County, and there was another fellow who lived in Alameda County, and his name was William O'Connell. In fact, my uncle, who also lived in Alameda County, was named William O'Connell. I was named after him. But more interesting about the other William O'Connell is he had a wife. Well, I have a wife. My wife is Nancy. His wife also is named Nancy. So you can see if you were looking for documents and all you had was the name William and Nancy, how would you know which William and Nancy the matter affected? So we need a statement of identity from the seller to tell us about themselves, who they are, who they've been married to, as I say, where they worked, where they've lived, social security number, date of birth, so we can look at liens and try and determine if that's our party or not. And it's interesting, a lot of people get real reluctant. You know how you're loath to let go of your social security number, but it is a problem that it's used for identity. I've always chuckled over the fact that if you look at your social security card, it says not to be used for identification purposes, and yet it's your primary source of identity. You want to borrow money, you want to buy a car, you want to buy a house, you got to have a social security number, and everything hinges off of that. Your credit score for getting the loan is based on your social security number. When they run a credit report, the prime item is social security number. So we need that information for clearing SI. Now, a lot of times we don't ask for it because when we run the name in the recorder's records, we don't find a lot of stuff, a lot of problems. So that's, if you're taking a listing, if you could get an SI form and take it with you while you're taking the listing and ask for the information at that point in time, it's a lot easier to get. It's always a problem to get when you have to go back afterwards and say, hey, I need this. Then the person wants to know why you suddenly need this extra information. The last item is FinCEN. The Department of Treasury and the federal government, in an effort to crack down on drug dealing, requires us to file reports on property in certain areas. So if you are selling property in San Francisco, Santa Clara, San Mateo, I believe Sacramento, Alameda counties, we have to do a special report, and we need special information for that. So it doesn't really affect anything. It's a flag to escrow that here's you're going to have to do a FinCEN filing, so you're going to have to get this additional information, an ID. Red flags to watch out for. If we're questioning a deed, a lot of times when we question a deed, we'll explain that there's a defect in the deed. Legal description might be wrong or something else. It's a good idea to look at that and at those paragraphs and see what it is we're asking for. I had a claim come up recently because I'm the guy that gets all the claims, where we handled a sale of property in San Joaquin County, and the assessor said they wouldn't reassess the property in the buyer because in 1992, the buyer's mother had entered into a lot line agreement with a neighbor to the south, and there was a 30-foot strip that needed to be conveyed. So to show you what I do, I have to now go back and figure out what happened, and I have to track down parties to get deeds or documents to correct a 1992 lot line adjustment that had nothing to do with the property I'm dealing with, other than in 1992, the then owner of my property agreed to give a 30-foot strip that wasn't really part of my property to the owner to the south. So when we're questioning a deed, a lot of times it's things like that. We've discovered that there's an error in a deed and it has to be corrected, and it can be time consuming. I just had a claim hit my desk today where the error goes back to 2004. It's the developer, when they sold the property, put the wrong lot number up for our property. So now I've got to go back to 2004 and chase down and get a deed from someone. So, you know, as I say, title insurance is not very expensive when you figure out what it covers. Now, there's a borrower's instructions here that would be telling us what to do with money. An owner's declaration. These are extraneous documents, an affidavit that may or may not appear in your pre. The lender, we always issue a lender supplemental report because they want certain additional information. The lender requires certain additional endorsements and coverage to their policy that the owner really doesn't need. The last thing on the pre, and this is, I don't think most people even realize it's there. The last few pages of a preliminary report are a list of the various types of policies of title insurance we issue and what they cover and don't cover. So a lot of times the buyer is looking at it, and for instance, a standard policy insures.
Hey, Bill, I'm sorry to interrupt. What page are, where are you exactly? We just got.
I'm on page 15.
15. Okay, thank you.
Yeah, these are, it's a list of the types of policies we issue and the coverage they give. The most interesting policy for most of you is the policy for residential real property. A regular policy of title insurance doesn't cover zoning violations, doesn't cover matters which a correct survey would show. It doesn't cover the encroachment of improvements on or off of the property, because those things aren't of record. But the CLTA, ALTA homeowners policy, which we call the America First, does include coverage for these things. And it also, the normal title policy is a picture of title at a particular point in time. So when the transaction closes, the policy is issued, it's dated that date. If something happens after that date, it's not covered by the policy. The America First or ALTA, CLTA policy ensures against some post-policy things. It ensures that if somebody forges a document with your name on it, you're covered. Think about that. You listen all the time on radio, you're hearing about buy our little coverage thing where we'll fix your property if someone forges your name to a deed or deed of trust or whatever. An ordinary policy of title insurance doesn't cover against that. Why? Because it happens after the policy. It's post-policy. But the ALTA, CLTA homeowners policy or the America First homeowners policy does ensure you that if someone forges a document on your property, we will take steps to defend your title and get the matter resolved. So one of the things that they're selling you in these other policies, you get with that policy. It also ensures you that if your neighbor, after you buy the property, suddenly decides he's going to move his fence into your property, we'll take steps to address that. It ensures you if you put your property into your trust. As I said, a policy of title insurance is a snapshot of title at a particular point in time. But let's say after you've been in the property for a few years, you decide to do some estate planning and transfer the title to your trust. An ordinary policy doesn't cover that, but the ALTA, CLTA homeowners policy, America First homeowners policy, does cover your title even though you've transferred it to your trust. So those are, for title insurance costs about 1%, 1.5% of the sales price of a piece of property. And so it gives you protection. It tells you what affects your property now. It tells you that the person selling the property to you does in fact own it. And if it's residential property, it will ensure you that if someone forges a document, a deed of trust, whatever, against your property, the title company will step up and defend you. It tells you that if you transfer your property to your trust, you're still insured. And to let you know, there is a court case where the court held that, a person had property in their name individually, transferred it to their trust. They made a claim for something that was a defect in title against their title insurer. It wasn't us, but they're against their title insurer. The title insurer denied the claim because they no longer owned the property, so they were no longer an insured. They went to court, and the court agreed with the title company that yes, there was no coverage for them because they were no longer an insured. So if people do that, then that's something to be aware of. If you do have a situation like that, there is an endorsement you can get to the existing policy that will ensure you that you're still covered. Then the last page of a it's page 20, is a map. So that's why I said it's a good idea when you're looking at your legal description to go look at the map and make sure the map and the legal description are matching. For instance, in our pre, you see that we say we're the south 25 feet of lots 1 through 8. And when you look on the assessor's map, or it's 3 through 8, I'm sorry. And when you look on the map, you'll notice there's a little dotted line that shows a 25-foot strip of land for lots 3 through 8. So a lot of times, you'll look at the legal and say, oh, I can't possibly track that. As I say, asking for a color-coded map, if you don't have one, is a good idea. But looking at the map to make sure that the map and your legal description match is a good idea. Other red flag areas, a lot of times, if we're dealing with senior citizens, we'll ask for, since elder abuse and taking advantage of seniors is more prevalent than we'd like to admit, we will ask for additional documentation when dealing with seniors, especially when we're looking at signatures that are very shaky and whatnot. It's usually nothing too difficult, too onerous, but it is important to know that we are cautious, we are protective of seniors. The statement of identity that I was telling you about, I had a fellow call up years ago and complain about having to give one, and he said that he didn't have to give that much information to the Navy when he got his top secret security clearance. Guess who had a top secret security clearance when he was in the Air Force? Me. So I explained to him that, gee, I did. We got the information. So it's important that we get information, because no one wants a claim. We don't want a claim because it costs us time and money. You don't want a claim because it upsets your buyer, your insured. Even if it's something that's covered, even if we're dealing with it, it's still an intrusion into their life. They have to deal with it. And so the more we can do to see that we don't have issues, the better it is for everybody. We're protecting you, we're protecting the buyer, we're protecting the seller, and that's our primary function. That's why we use escrow, because in escrow, you've got this independent, this neutral third party who takes in the money, makes sure that the seller is getting what he should get, or getting what he should get money-wise, make sure the buyer is getting the property they should get. And so our job as a title insurer, as a title company, is to protect the public, to protect real estate agents. We don't want to see you having customers hollering at you. And, you know, as you are well aware, if you've been in the business for a while, when something doesn't go right, the first person they look at is the real estate agent. So we try and make sure that the issue is as smooth as possible for everybody, and that we get what we need, and that nobody comes back. The legal description that I have to correct, we're going to correct it. We'll fix it. We'll make it good. But for right now, our insured still has to sit there and think, well, maybe I don't own my property. Well, yes, you do. We'll see to that. The company has been in existence for a long time. It's very solvent. Its cash flow was very good. So we're good, and we will see to it that the insured is treated properly and with respect.
Can I just throw out a comment for especially the newer agents? If you ever have a buyer, obviously if they're getting a loan, the lender's going to require title insurance. But if you ever have a buyer paying cash and doesn't want to get title insurance, call Randy or Gary. That's it. We need to put things in place to protect ourselves, protect us.
Mhm.
So just heads up, it's very unusual,
Yeah.
but it's, and they'll probably convince them to get it.
And we can
But-
also have your potential buyer get on the phone with our lovely Bill. We can arrange for Bill, our expert title concierge, who is here to support all of us in these unique situations. So we're incredibly grateful for your wealth of knowledge and service to us.
Yeah, we had a situation, another title company did in Florida several years ago, where a young couple bought a home, and they put $15,000 down, and I think the loan was about $75,000, $80,000. They didn't want title insurance. It was going to save them a couple bucks in the escrow. So they didn't get title insurance. Well, it turned out there was a defect that the title company had missed. The title company paid the lender, so the loan got paid off. And the couple goes, look, well, what about us? What about our $15,000? And title company said, well, you didn't get title insurance. You could have, but you didn't. They went to court. The judge told them the same thing. You could have gotten title insurance, but you chose not to. So it's really, unless you have money to burn, it's a very imprudent thing to do, to buy property without title insurance.
Absolutely. Thank you so much, Bill. Let's see if there's any more questions.
Yeah, does anyone online or here, questions? Bill's got lots of good info for us. He's a great
You
resource.
can
So,
either unmute yourselves, or you can type in the chat, and Heather can see your questions and speak them out for you.
I think everyone's just absorbing all the great info, like, oh my gosh, I've got to look again.
Bill, you brought up a wealth of information and topics for Carly to pull into our marketing pantry for all of these wonderful agents to make them the resource.
Yeah. All right, Alejandro's clapping and thumbs upping and things.
Yay.
Yeah, it is a lot to take in. Believe me, in 56 years, I've seen a lot of changes in the industry.
Yeah.
Wonderful. 56 years of wealth of knowledge.
Yeah,
Yes.
I'll give you his number.
Yeah. So we're going to have a lot of requests to talk to the great Bill O'Connell.
If nobody calls me, they send me home.
Well, Well, I know that I have Bill's back cave number if anybody needs to talk to Bill about special circumstances. We've called him about funny things with private notes and you know, different ways of reporting things. We've had, you know, an auction situation where we had to call Bill and get his expertise and some complicated things. There's, you know, investors, there's commercial things, there's things that are, you know, coming up in this very different market that we're approaching. So please know that we are so fortunate as a title company in my 25 years of experience to have somebody like Bill supporting our whole team, not just our sales team, but supporting our whole team to make available to you, the realtors, as well as your customers, your sellers and your buyers. It's just a phenomenal amount of support. So we're
Cool.
very grateful.
Thank you.
Thank you.
All right, thank you so much, Bill. No other questions? Did you want to ask a little bit about, Bill, you were talking about when there's, I forget what it's called, but when there's a violation on, you know, someone who hasn't taken care of the property. I've experienced that myself. I was helping a seller who had a letter of, I forget what it's called, from the city.
Abatement, yeah.
Yeah, it wasn't actually abatement. It was that they had to do a bunch of repairs. I
Right.
don't think abatement, but yeah, just what, any suggestions or resources of
Well,
what we do, where we go?
yeah, you have to find out what agency. For instance, in most cities, it's the planning department that covers abatement issues or issues that have to be corrected. Because they're the ones who review compliance with building codes and whatnot. And but in some cities, the police department is involved. So it's a good idea to find out I would start with the planning department if you have those issues and say where you go to find out what needs to be done to resolve it. And you know, you want to be cautious because you want to make sure if you bring in a contractor that A, he's licensed, and B, that he pulls permits and whatnot for when he does things. Because the worst thing you can get into is having done a lot of work and then suddenly find out it was unpermitted. And even if it meets code, now you have to go back and pay to have it inspected to certify that it meets code. So anytime you're having, you know, handymen are wonderful. If it's repairing a fence, great. But if it's anything electrical or plumbing or whatnot that could get you involved in code compliance, it's really a good idea to make sure you've got a licensed contractor doing it. And that if it's something that needs a permit, they pull a permit for it.
Yeah, great. Thank you, Bill. The situation that I had a seller, they received a notice either a day or a day after we went on the market. So they couldn't, you know, it wasn't like we can do all these repairs before we, you know, but we had great communications with the city who allowed it to, because we were working on things, allowed it to go ahead and transfer to the new owner, and the new owner took responsibility. But a lot of owners wouldn't want to do that, right? They're, you know, so, but we let everybody know upfront that it was a situation. So every situation is a little different there. So I appreciate that. Yeah. All right. Well, I think we are all good. Everybody, if you guys want to send out, or maybe we can put your emails in the chat.
Yes, that would be wonderful. You
Yeah.
can put, Carly Butler,
Okay.
sales representative, Gina Isola, senior escrow officer. and
Maybe
branch
do an
manager.
email and then I can just forward it to everybody that came
Perfect.
today.
Thank you so
So we
much.
will send that to you guys, and thank you so much, Bill. We really appreciate your time and all your
Anytime.
knowledge.
Thank
All right.
you.
Thank you, Mel.
Thank you.
Okay, guys, thank you very much.
Thank you so much, Heather.
Yeah, you bet.